This is a motion to revoke bond.
Your Honor, the state calls Aaron Jimenez.
You solemnly swear or affirm any testimony that you give in this matter will be true. And this is testimony in the case 2021 CR 06164. Mr. White, your witness.
Mr. Jimenez, please introduce yourself to the court.
Hi, I'm Aaron Jimenez. I know her from her being mother of.
Let's back up a little bit. Well, let's introduce yourself. How old are you?
I'm 24 years old.
Okay. And how do you know Miss Dorsey?
She is the mother of my child.
Okay. And
He's find my files. I don't know where they are.
Go ahead.
okay. Why did you call the police on June 29th of 2022?
I called the police because she was making more or less slight threats that were out of the normal. As she does usually just text my mother. So she reached out to me making threats of coming to get him. And was very, it was out of the ordinary normal because she doesn't usually message me. She usually messages my mom.
Okay, so I just want you to clear it up for me a little bit. So let's break it down. So you said earlier that you and the defendant have a child, correct?
Correct.
And why does she contact your mother?
She contacted us because that is our kind of our mediator between where we can drop off the kid and pick them up and whatnot.
Okay, so has she ever contacted you before you felt threatened?
Not really. She does contact me a lot. She does make disrespectful comments a lot, but it wasn't more or less threatening as in what was happening in the text messages.
So why is it then, because she had contacted you before, that you decided to call the police on June the 29th?
Because there were pretty vivid threats, and there was a time limit within those threats.
Okay. And would you recognize a copy of these messages she sent to you if you saw them today?
Yes, I would.
Can you take a look at that for me? Mr. Jimenez, after you review that, what did I just show you?
You show me messages of her threatening and asking for money and just a lot of talking.
Objection. He's going into the contents of the documents before they've been introduced into evidence. So we'd object to any testimony in reference to that unless the proper foundation is laid.
Mr. White.
Your Honor, we're not using these to show the truth of the matter asserted in the documents. We're using these to show that she made contact.
Mr. White, but your witness needs to understand that the evidence hasn't been entered yet. He's not to testify as to what is contained in the evidence, but how he recognizes.
Okay. Thank you, Your Honor. Mr. Jimenez, how do you recognize these documents?
I recognize them from my phone as they were sent to me on those current dates that are on those documents.
And to your knowledge, has any of these been altered in any way?
No.
And these are true of what she sent to you?
Correct.
Your Honor, the witness has now verified that this is what she sent her and has not been altered in any way. The state now moves to enter this as an exhibit.
Yeah, we object. First of all, there's not been a proper foundation laid. He's just testified. He hasn't laid the foundation. I don't want to give him the information to lay it, but he has not laid the foundation in order to get those documents introduced into evidence. So he's not done the necessary requirements, the foundational requirements in order to do so.
Your Honor, may I reply to that?
May.
We've already established before I tried to introduce this, that she sent him messages, that these messages were threatening. Then he verified that he recognized them. Then he verified that they had not been altered or changed in any way to his knowledge as they were sent to him. That is laid a proper foundation for these to come in, Your Honor.
Judge, he hasn't laid the foundation. First of all, he's making an assumption. The guy started testifying from documents that had not been introduced into evidence. So that testimony regarding those documents was not, he was testifying before they were introduced into evidence, number one.
Your Honor, I'm gonna have to interject here.
Hold on.
What?
Mr. Todd, I'm trier of fact in this motion, so it's minimal. I know what to listen to and what not to listen to. The objection was timely, and Mr. White has instructed his witness as to how he is to identify the document and not go into the content until such time as it has been admitted. So Mr. White has laid a proper foundation. The court will admit the evidence over objection.
Judge May, I understand the court's ruling. I would ask the court to allow me to respond to that. In order to, yes, Judge, in order to have those documents introduced, he has to lay the foundation. I'll give you an example. He hasn't testified as to where it came from. In other words, by telephone number, by the URL, by some means of identification. He's not done that. So
Your Honor, I may
just
have to interject here.
Mr. White, you can't interject. You wait until Mr. Todd is finished and then you
Yes,
can
Your Honor.
respond or make
I
your.
apologize.
Okay,
Judge, there's a proper procedure in order to introduce those documents. In order to, he has to authenticate them. He has to testify as to where they came from. How? In other words, by phone number, by if it's a internet, you know, what the internet address is. There has to be something more than just says that's from somebody. So he has not laid the foundation at this point, Judge. He's not identified them properly and introduced them properly by, you know, setting the foundation so we can know that these documents came from whoever he's testifying. You just can't say they came from Joe Blow without something more than that. That's all he said.
okay.
Your Honor, may I respond?
Go ahead, Mr. White.
Mr. Jimenez earlier said that this was sent to his phone. I don't know if the opposing counsel heard that statement, but Mr. Jimenez indeed said where they came from and how he received it.
Okay, the court is satisfied that Mr. Jimenez did state that he had received text messages and that he had received them from the defendant. So the court is satisfied that a proper foundation has been laid over the objection of the defendant's counsel. Court is going to admit Exhibit 1 for the state.
Mr. Jimenez, can you take a look at these again for me? And could you tell me the date of which she sent these to you?
From the 27th through the 29th.
And where in these messages did you feel threatened?
First section where she was.
You can read it if you need to.
Yes, but there was more to it. Basically, when she said I got 3 days, she just said I had 3 days, and I'm not too sure what she was talking about. Then she went more into the depth of where she described my girlfriend's house, knowing where she lived, and describing the bedroom as well as if she was in the room. She continued to say that she was going to, if she see me on the street or see me somewhere, that there would be an issue and there would be a problem, that she would act upon in doing so. And that's more or less kind of where it was for me threatening. Other than that, it was more or less just a lot of sexual talk.
Okay.
So, Mr. White, Mr. Jimenez, the court has to make a decision about whether I'm going to take away somebody's freedom. And so I can't entertain more or less. I have to have this was threatening. This was exactly what she said. I can't do
Yes.
yada,
I just
yada,
need,
and all of that. If it says it in the text message, then I need to know exactly what it says because
Yes, Your Honor.
you're asking me to take away somebody's freedom.
Yes, Your Honor. Could you read verbatim of where she threatened you and why you felt threatened?
she responded saying, quote, "You got 3 days." Let me find some more quotes. She said, no.
Okay, let me ask this, Mr. White. Was there a bond condition in this case?
Yes, Your Honor. The bond condition was there be no contact with Mr. Jimenez.
Do you have the bond from?
Yes, Your Honor.
Okay. Can you share that with the court?
Yes, Your Honor. That's right. Your Honor, do you want me to show it to you? Or do you want me to just read it to you?
Can you show it to me?
Yeah.
So the court sees the bond condition, which court recalls as a document prepared by magistrate court judges at first appearance. I see that the name Aaron Jimenez is in the area where it says that the person is to stay away from that person. Absolutely. And there's also an address located in Hampton, Georgia. All right. So as I said, if we're talking about threats, then they need to be specific. Mr. White, you may continue with your witness.
Yes. So you use it back on? No, we have to use the documents. Okay. First, I want to establish, how did you know that the defendant sent these to you?
She started off by saying, "Come get your love child," which would mean my son, and the only person that has my son would be her.
Okay. And then where did you feel threatened exactly in these messages?
I felt threatened when she said I got 3 days.
Okay, so you got 3 days. And earlier you said you also felt threatened because she knew about your girlfriend and her living situation. Can you point that out to me also?
Yes.
And just read it verbatim.
She said, I'll just read the whole thing.
Yeah, go ahead.
The one that don't got to Photoshop all her pictures and use her card to cop N-word, because her stomach claps with her pee, her private part, kitty flat, like pancakes, staying in a one-story house. I'm the only girl you give money to, and nutted in 5 years and cried.
Okay.
Sorry.
No, that's completely fine. So she told you she knew where your girlfriend stayed, and she told you that you have 3 days.
Mm-hmm.
Mr. Jimenez, tell me what happened 3 days later.
My car was vandalized, as well as my girlfriend's car was vandalized.
Can you tell the court what happened to your car?
My car front lights were hidden. My driver's side mirror was bashed over. My gas tank was pried open, as it's not a push gas tank. You have to press a button inside the car to open it. So it was pried open. Gas, there was Diet Coke or Coke, Pepsi in the gas tank, as well as for her car, it was just opened with the Coke or Diet Pepsi, whatever, in her gas can. But mine had the most damage.
Okay, and just to walk me through it, so your car was damaged, your girlfriend's car was damaged. What was the parking like? Or is it just the two of you parked there?
No, there was about 5 to 6 cars, as well as no windows were broken, so no one stole anything. There was 5 cars on the driveway. Only both of ours were touched after being told where we stay, being threatened, as well as she knew where she stayed, so we knew that she knew where she stayed at, so she was able to. Yeah.
So let me try and break this down and clarify. Your car was at your girlfriend's house.
Correct.
There were multiple cars there, correct?
Yes.
And none of the other cars besides you and your girlfriend's cars was touched, correct?
Correct.
Okay. Mr. Jimenez, what else has she done to make you feel threatened?
She reaches out to family, friends. She took out a life insurance policy against me.
Judge, I'm gonna
Hold on.
Judge, I'm going to interpose. The first objection is hearsay, talking about other people.
Yeah.
Number one. Number two, I don't know what he's talking about as far as an insurance policy, but that would be number one, irrelevant. Number two, the highest and best evidence would be the insurance policy if he's testifying about something about some insurance policy.
Sustained hearsay.
Yes, Your Honor. I just have one last question for you, Mr. Jimenez. After the defendant was told to stay away from you, has she contacted you more than that one time that you used those messages?
Yes, she has contacted me more than once. Sometimes it won't be as threatening as that per se. It would just be more or less, come get your son, and I would redirect her to contact my mother, as she is our middle ground. So yes, she has contacted me more than just that, but those were again with the most threatening recently, and with all that's happened with the threats and some actions, it was a little bit nerve-wracking.
Thank you. Your Honor, may I have a moment to confer with my counsel?
You may.
Thank you, Your Honor.
You want to mute?
Yes, Your Honor.
Go ahead.
Your Honor, no further questions at this time.
All right. Mr. Todd, cross-examination.
Yes, Your Honor. Mr. Jimenez, isn't it true that you had a child with you and Mrs. Dorsey? Isn't that correct?
Correct.
And you, prior to recently here, you had, most recently after this situation started, you had never legitimized the child prior to this time, correct?
One more time?
Objection, Your Honor.
Yeah,
Relevance.
Judge, we're showing motive of the reason why he's testifying. We're going to lay the groundwork to show, Judge, that he, in fact, has made up a lot of this stuff for the purposes of trying to get custody. And I'll lay the groundwork as I proceed forward to show the court what he has done and what has transpired during this period of time to show his motive.
Okay, overruled.
Okay. Mr. Jimenez, isn't it true that you filed this incident, this complaint against my client because you were, at the time, you had not legitimized your child? Isn't that true?
No.
Okay.
I filed this due to safety.
Okay. You have now filed recently here in the last few months, you filed a petition to legitimize the child. Isn't that true?
Correct.
And you also filed a petition in that legitimation to get custody of the child. Isn't that true?
No, it was 50-50. I think that she denied it, and then we went for full custody due to she didn't want to give me access to my son.
Okay. So you're saying that you filed it because she wouldn't give you access to your son. Isn't it true? Isn't it true that you had not legitimized the child? Isn't that true?
We have. I think we did that yesterday or the day before.
Sir, just answer my question. Yes or no, you can explain it. You had not legitimized this child. Isn't that correct during the time that all this happened?
Objection, Your Honor. Mr. Jimenez was answering the question and explaining it, but the counsel was asking an extremely vague question.
Okay, let me clarify the question. Up until the time where you went to the solicitor's office and let them know that you felt threatened had you legitimized the child?
No, because the court was delayed for Corona. So we had it like 6 months before that. It got delayed for 6 months. We just had it recently. And yeah, so this was only because of delay, not because it's filed after.
So to answer my question, the child was not legitimized, so you were aware you had no legal rights to the child. You were aware of that, correct?
Okay, yes.
Okay. And you were also aware the fact that Mrs. Dorsey, even though you had no legal rights, she allowed you and your mother to visit with the child. Isn't that true?
No, she would drop us off at random times. So not visit, more or less drop us off so we could see him. Yeah. But we wouldn't visit, more or less go over there. So it wouldn't be more or less going over there for a family.
Sir, you remember we just 2 days ago had a full-blown hearing on your request for legitimation. Do you remember that?
Correct.
You remember testifying, you and your mother testified that Mrs. Dorsey had allowed you to see this child for numerous days, okay, and had brought the child over there.
Correct.
Okay, so she had allowed you to visit with the child even though you had no legal rights to do so. Isn't that true?
I would assume so. I was asking because I'm confused if you're asking if visiting meaning going over there, or if she was coming over here, or if she was dropping the kid off.
Okay, sir, you understand the question. You are able to read and write, are you not?
Correct.
Are you on any drugs today that would prevent you from understanding my question?
No, sir.
Okay, so just 2 days ago, did you not testify in this legitimation case in reference to the visitation? And I'm referring to the fact that the child was allowed to stay at your house with your mother to visit with the child. And when I say visit, to keep the child.
Yes, thank you for being more accurate. I appreciate you. Yes.
Okay. So, and that was done on numerous occasions. She allowed you and your mother to see this child, correct?
Correct.
Okay. And also during this period of time, you had indicated, you had never indicated to the court in the hearing that we had, you never indicated one time that about this incident that happened now that you're telling us about in June. You never mentioned that previously, isn't that true?
I did. I didn't mention the details within the context of what was going on, but I did mention it.
Okay. And did you ever testify? With that's being taken down under oath, that hearing, that trial that we just had was taken down under oath. And I'm asking you the question, did you testify at that hearing?
Objection, Your Honor, to relevance about another trial and what he testified to when there is physical evidence of said conversation.
Overruled. Go ahead, Mr.
Sir, just a couple of days ago, when we had that full day hearing in your case, you never once mentioned about now this incident that you're claiming happened on June the 29th of 2022. Isn't that correct?
Again, I didn't say the exact details, but I did say that there was a bond being revoked. Yes.
Okay, you said there was a bond being revoked. You never mentioned at one time.
I think,
sir, excuse me, sir.
Mr. Jimenez, you have to wait. Nobody gets to talk over anybody else.
Yes, ma'am.
It's been a long day and my court reporter is exhausted. So if we got to have these pauses that I got to impose, I'll do it. But you cannot talk over Mr. Todd, and Mr. Todd can't talk over you, and Mr. White can't talk over anybody. Okay?
Yes, ma'am.
All right.
Sir, my question to you is very simple. You never mentioned in that whole trial about an incident happening on June the 29th, 2022, where you felt threatened or she had sent you any type of threatening email. Isn't that true?
Correct, because these are two different trials. That was a trial for my son. This is a trial for her.
Okay. But you mentioned other things during the case of the trial that we just previously had, that you had problems with my client. You testified about some other issues, correct?
Yes, revolving my son, yes.
Right, okay. But you never brought this so-called incident or this situation regarding you felt threatened, correct?
I did feel threatened and didn't mention that, but yeah, I didn't mention that, so I'm not too sure.
Okay, and now you're saying that you felt threatened because something there's in these emails, I haven't seen them, I haven't been provided to me, but be that as it may, something about 3 days, something about 3 days, okay? There was no actual threat, for any type of harm or damage to you at any point, isn't that true?
There was a lot of evidence of her after her saying 3 days of her when she sees me, there will be issues. There is a lot of evidence regarding that factor.
Okay, isn't it true that she cut off relationships with you back in January or February of 2021?
I do not recall.
Okay. Do you recall on Mother's Day that you went to her house, Mother's Day being May the 12th, 2021? Of course, you're not supposed to, according to the bond conditions, you're saying that not supposed to have any contact. Isn't it true that you have attempted on numerous occasions to contact Mrs. Dorsey?
Negative. She requested that I give, if we don't give her something, there will be consequences for those days. And I think we have those text messages as well.
Okay, so let me ask you this. Isn't it true that you went to her house on Mother's Day, May the 12th, 2021 to give her flowers?
I did drop them off as they were requested.
Okay, she requested you give her flowers for Mother's Day?
Yes, and I think she requested that for this year as well, but I'm not too sure.
Okay. Now,
Was that, hold on, the Mother's Day flowers, was that this year?
I'm not too sure, but this year, I doubt it was this year, but I think it was last year. So.
Okay.
and knowing that you're not supposed to have any contact with her, you went to her house to deliver her Mother's Day flowers. Isn't that true?
Yes, as she requested to possibly get my son. Yes.
Okay. And now you keep saying to get your son. Okay. Now, didn't you just previously testify at the prior hearing that that was when the son was born? Okay. She said to you something about you came to the hospital empty-handed. That was back 2 or 3 years ago. Isn't that true?
You said what say that again? Sorry.
When the child was born. When your child was born, Kingston.
Correct.
You know who I'm referring to?
Correct.
Didn't you testify previously that she told you you came to the hospital empty-handed? That's when she was looking for something?
She did.
All right. It had nothing to do with Mother's Day and presenting her flowers. And...
That's a different situation.
Okay.
You're talking about hospital visit and then dropping flowers at her doorstep.
That's correct. 2 different days, two different times, right?
Yes, which were more the same, was exactly the same thing as she was requesting stuff. So if we didn't have stuff, I wouldn't get my son.
Okay. And stuff, when you're referring to stuff, are you saying that she asked you to deliver her flowers for Mother's Day? That's what you're telling us.
I'm telling you that she did ask for flowers on Mother's Day. I'm talking about for the hospital situation. She did ask for stuff. She wanted Pampers, wipes, stuff like that. My mom was already bringing that, but she didn't know that at the time, so she was very upset with me.
Okay. And you never provided any child support for many, many months after this child was born, correct?
The child support I provided was Pampers and diapers and wipes and the date and everything that was in his room that was provided by us.
Right. That was that one-time visit in the hospital.
No, that was multiple visits by my mom because I didn't want to get kicked out and we had to make a schedule to be able to see my son because apparently us together in the room wasn't going to make it. And I couldn't see my son and I wanted to see my son.
Okay. Is that why the police had to escort you out of the hospital when the child was born?
Okay, we're getting a little far afield.
Okay.
So from the date that the bond condition was imposed, who contacted who first? That's what I need to know.
Sir, okay, so the judge is aware of it, you continually contacted my client to get back with her to resume the relationship. Isn't that true?
Negative.
Okay. Let's talk about the Mother's Day, the week after, the week of May the 17th. Okay, I'm going to refer to that just shortly before this June. Had you not contacted her on numerous occasions, sent her emails in order to, that you wanted to get back with her?
I don't use email to contact.
Text messages.
I don't recall sending her anything. I don't think I messaged her in about almost a year now,
Okay.
if
So-
not more.
Okay,
And that's
how
due
about-
to her messaging me first and trying to redirect her to contact my mother so I'll be able to see my son.
Okay. How about
Yes.
the June the 22nd, 2001? Did you not continue to text her on a regular ongoing basis? Telling you that you were sorry for the way you treated her? You wanted her to get back together? Do you recall that?
I do not recall that.
Okay. How about June the 25th, 2021?
I mean, these are kind of old dates, but if you have evidence, I don't know what you're kind of referring to. You're just referring to dates.
I've given you the specific date of June the 25th, 2021.
Right, but I don't know what you're referring to as in what that date is for.
I've asked
Like
you,
what?
sir, I've asked you to say that during that date and on that date, you continue to text her, to contact her, to get back together.
Objection, Your
correct?
Honor.
What's the objection, Mr. White?
Your Honor, the opposing counsel is trying to ask Mr. Jimenez about a specific date, and he's given him a response. He doesn't know what he's talking about. Now, if the opposing counsel can refresh his memory, he can do a lot of things.
Mr. White, okay, this is something you'll learn about me. I detest speaking objections. Really, it's either relevance or a badgering, or it's a one word. Give it to me, because by the
Badgering,
time
Your Honor, badgering.
you make the objection, I've already thought it through and decided pretty much. So here's the thing. Mr. Todd is entitled to a thorough and sifting cross. I have yet to have Mr. Jimenez actually answer the question. He keeps asking for clarification on the question, but he has yet to answer the question that's being asked. And so, Mr. Todd, ask your question again. Mr. Jimenez, you're not asking questions of Mr. Todd, you're answering the question, okay?
Correct.
If you
Yes,
need clarification of a question, ask, sir, could you clarify for me? I don't know what you're saying.
Okay.
Okay.
Mr. Jimenez, trying to be as very clear and precise. On June the 25th, I'm giving you a date of 2021. Isn't it true that on that date that you continued to text Mrs. Dorsey on numerous occasions requesting that you all get back together?
I don't recall.
Okay, I'm gonna bring you here to August of 2022, right? We're in August this month. Okay, did you not contact Miss Dorsey, okay, by using a different telephone number to try to contact her in reference to getting back together and wanting to go out with her?
No.
Okay. And on the date of whatever your date you're saying something happened, June of this year, you never whatever you received by way of emails or text messages, you never contacted the police and made a police report that you felt threatened at any time. Isn't that true?
I have. Well,
Did you contact the police?
yes, and that was on that date.
Did you make a police report?
Yes.
Okay. And was anything done as a result of that police report? Did the police, to your knowledge, go out and contact my client, make an arrest? Did they do anything in reference to that?
I think we're here for that now.
I'm asking you, did they do anything at that time? You went to the police on that date. That was June. You just told us June the 29th. We're here at least several weeks later, okay? Almost a month later, okay?
Okay.
And the police did nothing after you contend that you reported this to them. The police took no action. Isn't that true?
It was more, I'm not too sure the action that was taken or not.
That's fine. If you don't know, you don't know. That's perfectly
Yes, I don't
fine.
know.
Okay. And this, whatever you're talking about, as far as your vehicle is concerned, you never saw anybody do any damage to your vehicle. Isn't that true?
Yes.
Yes or no? Did
Yes.
you witness somebody? You witnessed somebody? Who did you
I
witness?
didn't witness anything with my eyes, no.
Okay, that's my question. And also, you have a problem with other people. You hang out with gang members, isn't that true?
Objection, Your Honor.
No, I do
Objection,
not.
relevance.
I play video games in my room, my sir.
I got you. So you don't have any,
The judge can respond to that, Judge.
Yeah, I don't know that I appreciate the characterization, but the question as to if there's a possibility of somebody else committing the damage is a valid question. So I will overrule the objection, but Mr. Todd, can we be more specific?
yes, isn't it, let me ask this, isn't it true that prior to all this, your car was shot up at a hotel? Isn't that true?
Negative.
Your car's never been shot up at a hotel?
No.
Okay. On this occasion that you're referring to, that your car was damaged, you did not physically, personally see anybody do any damage to your vehicle, correct?
No, just the ring cameras that was placed on the house.
Okay, well, I mean, do you have a ring cameras that shows who did the damage to the property?
I don't think it shows it accurately about who shows it, but I think it still has a good picture of them.
Okay. And just for clarification, during this period of time, and I'm referring to 2022, we're talking about this year, on numerous occasions, my client has allowed the child to visit with you and your mother at your mother's property, correct?
At what date? I'm sorry.
In 2022, we're here in this year, 2022.
Yeah, I think we watched him a couple of months this month or this year. Sorry.
Okay. You are aware that you're not supposed to be trying to contact Mrs. Dorsey. You're aware of that, right?
Correct.
And you have been over to her house on numerous occasions while this order was in place, correct?
I'm not too sure if I did or did not.
You don't know whether you went to her house? You don't know that?
No, due to me having to pick up my son. So there were some instances where I had to be accompany my mom due to her aggressive behavior. So I had to bring a witness with me to be able to meet her at her house. So I don't know exactly the dates that I were over there, and as well as if they were inside her house, outside her house, or if she was just meeting me somewhere. So I don't know exactly the dates. So I would have to say I don't know.
You don't know. Isn't it true, and you've heard testimony from other witnesses, that you went into the house, had an argument with Mrs. Dorsey while her mother was there and the boyfriend? You recall that testimony?
Yes, and that testimony was dismissed due to the witness lying about what had happened on that day and or even relevance of being there.
Sir, the person testified. His testimony was not dismissed. He would testify in court.
Yes,
Okay,
yes.
correct? You remember that?
I remember his testimony, yes.
Okay. Remember him testifying that he told you to leave because you were loud, boisterous, and using profanity?
Oh, this is a different one. Okay.
You remember that?
I remember what he said, yes.
Okay. And told you to get out of the house, to leave the house because you were causing a disruption and a disrespect while you were at where Mariah Dorsey was living. She was living there at that day, on that date and time, correct?
I'd assume so, yes.
Okay. And at that point in time, on that day, you actually took her phone. Isn't that true?
No, Your Honor.
Okay,
I mean, no. So I don't know why I said that.
that's fine. And isn't it true that you contacted one of her friends, Mrs. Rump, in reference to attempting to get back with Mrs. Dorsey? You had contacted her because you know she was one of her friends, and you contacted her in order to try to get back in touch with Mrs. Dorsey. Isn't that true?
No, I think all of them had contacted me via Instagram trying to follow my private account. I didn't accept. I messaged them due to wondering the relevance of trying to follow me. And all of them were more or less nice and or blocked me from me asking.
Yeah. Isn't it true that Miss Dorsey had blocked you from her texting? Isn't that true?
I don't know because I do not text her.
Oh, okay. When do you say the last time you text her?
That would have to be that day of me getting threatened.
So that would have been back in January.
Well, like, yeah, January, I think it was the 29th. I think that was the last day. I think she started at the 27th and it ended on the 29th, and then 3 days later, the car.
Okay. And are you talking about what year and what month?
Say that again?
What year are you referring to? What month and year are you referring to?
January, right?
January. No,
It was the text messages. January, I think. June.
June of what year?
This year.
So that's the last time you text Mrs. Dorsey?
Yes, because I was being threatened and asked to pick up the son.
So you contacted her?
No, she contacted me and I responded because I wanted to pick up my son. So to make sure of my son's safety, I responded back to meet at a police station. So I asked her to meet at a police station. She said no multiple times. Then we continued to ask for money for me to meet her. I denied. She kept saying she threatened you have 3 days to come pick him up. If you don't pick him up.
I'm going to object to the,
Okay.
He's not answering the question. He's just going off on a tangent. We're trying to repeat himself.
Sorry.
My question was very simple. When is the last time you text Mrs. Dorsey? Very simple.
The
That's
29th.
the question, Mr. Jimenez. I don't need to know the whole content of why you texted her. The question was asked as to when.
June 29th. I think that was the last day.
Okay. And that's the day you're stating that this alleged message you got from her, I guess, from some text message where you said you felt threatened. And then you also said that there was on the message that you did a lot of sexual talk, is what you said. What kind of sexual talk went? Wait a minute, let me finish my question.
Yes.
What kind of sexual talks did you have with Mrs. Dorsey on that day?
I didn't have any sexual talks. It was her trying to get me to come over there to have sex with her.
Okay, so now you're telling us that she contacted you, threatened you, you felt threatened, but yet she was contacting you to come over to her house and have sex.
Exactly. Right? Exactly.
Okay. Isn't it true that you put fake photographs on the internet of Mrs. Dorsey?
No, everything was from her and my camera roll or sent from her.
Okay.
And I don't post her at all. And I don't think I've ever posted her a day in my life. You can.
And just so we're clear, as far as at some point in time in 2021, you had asked Mrs. Dorsey to marry you. Isn't that true?
I don't recall.
Okay.
Mr. Todd, can you focus on whether it was before or after the bond condition? Because I'm only interested in what happens after the bond condition was imposed.
Okay. Then after the bond condition was imposed, did you not in fact contact Mrs. Rump in reference to locating Mrs. Dorsey and finding out where she was staying and what she was doing Did you contact this witness?
I didn't hear you that good on the question.
Okay, I'm talking about after the bond condition was imposed. Did you contact Mrs. Rump? You know who she is, correct?
Yes, I think I don't know names. I just know faces.
Okay, that's one of her friends.
Okay.
Okay. And did you not contact her after the bond conditions in an attempt to get in touch with Mrs. Dorsey to get back with her after these bond conditions were imposed?
No, the only time that was messaged, I think, to the one friend that you're mentioning was via Instagram, and that's because they reached out on Instagram to follow.
Okay. Just 1 minute, Judge. Mr. Jimenez, now after the bond condition, isn't it true that you went over to Mrs. Dorsey's house and you guys had sex?
I don't recall.
Okay. Do you recall me showing you the picture where you had your hand around her neck, choking her after the bond conditions were in place?
Objection, Your Honor. Mischaracterization.
Answer the question, overrule.
No.
Sir, do you remember the video that we played of you vaping at her house after the bond conditions? You're under oath, sir. I'm just to remind you, because we've got you testifying in court, and I'm going to bring this to the court's attention. So I'm just letting you know that we went through a whole trial on this.
Yes.
So I just want to make sure it's clear. My question to you is, after these bond conditions were imposed in January, my question to you, isn't it true that you were at her house after that time and you guys had sex at her house?
I don't know, because I don't remember that day. And I feel like, if anything, if had sex would be before the bond condition. Okay.
My second question is this: did you not observe the video that was played showing you with your hand around her neck after these bond conditions were imposed?
I do remember the video, but I don't remember that date.
Okay. Isn't it also true that you threatened to kill yourself if my client, Mrs. Dorsey, did not speak with you after the bond conditions were put in place?
Wrong.
You didn't? Did you previously testify under oath that you threatened to commit suicide?
I did. I testified that it was before the bond condition.
Okay.
Correct.
So it's your testimony. You're saying it's before the bond condition, not after the bond condition.
It was whenever I went to China. So that was whenever I went to go, whenever she met me to meet my son at a gas station before I went to China.
Correct.
Yeah.
And you went to China in January after the bond conditions. This whole thing happened back in January. In February, the end of January, February is when you went to China for 10 days or 2 weeks. Isn't that correct?
Yeah, about 2 weeks.
Right. So the bond conditions were in place at that time, okay? And at that point in time, you had contact with my client after the bond conditions were in place. Right before you went to China, you had contact with her because she allowed you and your mother to visit or have the child stay at your house for several days, maybe a couple weeks during that period of time, correct?
Yes, a month, yes.
Okay.
I wasn't there.
Okay.
So she did stay, my son did stay with my mom as I was in China. She did reach out, and I did threaten to kill myself due to the volume of disrespectful and utterly disrespecting, disgusting stuff that she was just calling me and talking to me. So yes, I did. And I was in a hotel room for 2 weeks. So all I could do was talk to her when she would just destroy my ego.
Okay. So you spoke with her while you were in China and this court order was in effect. You spoke with her at that time, correct?
Yes, as she reached out, yes.
Okay, okay, sir, I'm going to show you what I'm going to have marked, defendant's exhibit number 1. Okay? And I'm going to show this to you, this photograph. Okay, can you see that? Let me get it over here.
You have video. Show a video.
Okay, can you see that photograph I showed you?
That's a video. They had that. Show.
Mr.
Mr.
Jimenez,
Jimenez, is this a photograph of when a picture of you and Mrs. Dorsey in that photograph?
It seems to be.
Okay, and isn't that place where this photograph is taken at her house?
It looks like it.
And isn't it showing the picture? Can you see where you got your hand choking her around her throat? Can you see that?
I do not. I don't know if it's on her chin or what it is, but yeah, okay.
All right, and this is after the bond order in this case. This is in November of 2021. This is like 10 months or 12 months after the bond conditions were put in place. You see that?
Your Honor, objection. One, the relevance, and two, the foundation. This has been published, but it has been a foundation. That one, it hasn't been even tendered, but it hasn't been a foundation for it to come in the first place.
sustained as to foundation, overruled as to relevance.
Okay. Isn't that a picture in reference to you having your hand around her neck?
Well, Mr. Todd, did you hear the court's ruling about foundation?
No, Judge, I did not. I'm sorry.
I said I sustained it as the objection as to foundation, as there being a lack of foundation, but I overruled it as to relevance.
Oh, okay. Well, let me ask you this, sir. That's you in the picture, isn't it?
I think so, yes.
And that's Mrs. Dorsey in the picture, isn't it?
Correct.
And that particular place is at her house, correct?
It looks like it if she didn't change the room.
Okay. And what were you doing over at her house on that occasion?
Your Honor, the state will still renew its objection in that one of the witness never positively identified himself, nor did he identify Ms. Dorsey. He said he believed that's him, he believed that, or he believed that's his house. And so the line of questioning would be inappropriate, since seeing that he never positively identified himself. The picture, what's showing on the video is really grainy, and so it's hard to even make out what's happening in the thing for identification purposes in the first place.
Okay, overruled, but overruled based on the fact that they've discussed this event based on his testimony in the previous hearing. So they've already talked about this. So the court's going to overrule the objection. All right, so here's the thing. Let me just put y'all in the mind of where I am. I'm hearing testimony regarding threats, but I'm also hearing testimony regarding contact after the imposition of a no contact bond. And I don't know that we need to go further down this road of the back and forth between two very immature young people who share a child, poor baby. But what I need to know is what was the nature of the contact between the parties after the no contact provision? Because, and this is where my mind is, and I just want to direct whatever goes on next on either side. While there is an absolute no contact provision imposed by Ms. Dorsey, and there isn't one imposed upon Mr. Jimenez, if the alleged victim in a case contacts the person who is the defendant in the case, then the court has to look at, from a fundamental fairness standpoint, whether I can jail the defendant when the alleged victim has engaged in repeated contact over the course of a long period of time with the person that they allege has done them harm, and which the court has said this person needs to stay away from you. But there's been back and forth mutual contact. And so just so you know, I've seen enough on both sides, testimony from both sides at this point to show that while, yeah, there was contact from Miss Dorsey to Mr. Jimenez seemed to engage in just as much contact or more with Miss Dorsey. So if y'all want to wrap this up, this is where I am right now.
Well, Judge, I've only got cross-examination. Of course, I have other witnesses that will testify.
I got you, but I'm
So
telling
forth.
you where I am right now.
Well, I don't think we need to put any more up, but that's, we have other witnesses to corroborate all this. So,
I don't really need to redo the custody hearing. All I need to know is whether there was contact and who made the contact, and was it after the date of the no contact provision, and what was the nature of the contact. So, Mr. White, do you have anything else on behalf of Mr. Jimenez?
Your Honor, is Mr. Todd concluded his cross-examination?
Mr. Todd, do you have any more cross-examination of this witness?
no, Your Honor, I've concluded my cross-examination.
Okay.
Your
Any-
Honor's heard it.
Any redirect, Mr. White?
I have one more, Your Honor.
Yes, Your Honor. Your Honor, I'm ready to start.
All right.
Mr. Jimenez, between January 7th of 2021, when the order came out, and today's date, August 25th of 2022, have you ever initiated contact with the defendant?
I have not.
Okay. And when she messaged you, were you trying to engage her, or just were you trying to respond to her?
More or less, depending on if she messages from one of her main numbers, I wouldn't know if it was her. So I respond regardless, trying to find out who it is. And what was the next question you asked?
That was good. And earlier on cross-examination, the opposing counsels asked you whether or not that you had contacted the defendant's friends. Have you ever initiated contacts with the defendant's friends who get into contact with the defendant?
I have not.
And after the defendant's initiation of contact with you, have you, we said earlier that you contacted the police. In that instance, where you contacted the police because of the defendant, who initiated that conversation?
She initiated it.
Oh, what he did? He sent me pictures of myself. And
Miss Dorsey, I can hear you.
Okay. And what police agency did you file a report against the defendant with?
I think Fayette County.
Fayette County?
And they sent it here, I think.
Okay.
So I have to go back.
And if I were to show you a copy of the police report filed in Fayette County, would you recognize it?
Yes.
Okay. What did I just hand you?
My statement for the Fayette Police Department incident.
Judge, we're going to object to him. There's not a proper foundation laid, unless they got the police officer here that did the report. Judge, that would not be admissible in court. So we would object to number one, there's been no foundation laid in this case for him to testify from the document.
Mr. White.
Your Honor, I'm currently laying a foundation.
Okay, let him continue. All right, go ahead, Mr. Wright.
Is that a police report or your statement?
A police report. I think she got my statement when I was there.
Okay. What is the date of that report?
Your Honor, we're going to object now. He's testifying from the report of things contained in the report without the report being introduced into evidence. The report is not in evidence. He can't testify.
I'm just refreshing memory.
Sustained.
Do you recall when you filed a police report?
Yes, I think it was the day of me getting the message from her.
Mhm.
It was the day of me getting the message from her. I think that was the 27th.
What 27th of what day and year? Month and year.
June of 2022, I think.
Okay. Okay. What led you to file this report?
Her saying that I have 3 days. She went on I guess I can only talk about what this is. She just kind of just messaging me and threatening me based on like her
Your
saying.
Honor, we're going to object to the characterization as threatening. There's been no threatening. He did testify that he received contact, but there's been no threatening in this case.
Your Honor, may I respond?
Oh, overruled.
You ask the question again, please.
Why did you file this report?
I filed the report because it was.
Judge, I'm going to object that it's been asked and answered at least 3 or 4 times. So
Okay.
we
So
want to rehash it.
he was in the midst of answering when you objected to the characterization of threatening. I said he could answer, so I'm gonna let him finish the answer and then we can move on.
I was scared because I didn't know what was going to happen after those 3 days. Honestly, that's it.
Your Honor, may I have a moment to confer with my co-counsel?
Okay.
Thank you, Your Honor. And after you filed the police report, did you contact any other agency?
Yes, I came here.
With the Solicitor General's office?
Correct.
At what point did you come here?
Not too sure if it was the day of or a day after.
The day after what? Day of or after what?
The day of or after me going to do the police report.
And why did you file that report?
The police report.
Yeah, so when you came to our office, what is the reason, the reason that you came to office, like that report? What was that report about?
Oh, it was basically due to what she was saying. And I don't know if that was after or before the incident though. It's been so much going on, I'm sorry.
This one too. All right. I'm showing you what's marked as State's Exhibit 2.
It was after. Okay.
Can you identify what State's Exhibit 2?
It is the affidavit and the
Objection, Your Honor. He's testifying from some documents that have not been introduced into evidence.
I'm laying the foundation currently, Your Honor.
Well, he's testifying from the inside the document, what's contained in it, not the basis for the laying the foundation for it.
If I may respond, he has not testified to a single detail of the document. He's merely identifying what the document
All
is.
right, stop. Mr. Todd, sustain. So I don't know that it's relevant, whatever you're about to introduce, because all I need to know is he made a report. He already testified that he felt threatened. So, and it's all around the same time. So I'm clear. I think we're beating the proverbial dead horse. And if you don't have anything else to add from because we don't have anything so far in testimony that he knows who damaged the vehicles. The ring camera was seemingly inconclusive, or I'd be looking at it. And so if this is all y'all have for June 27th through June 29th, then I don't need to keep hearing the same things over and over again.
Your Honor, I think the state was intended to offer this into evidence as a prior consistent statement. Opposing counsel challenged that the witness made these statements, but for the custody proceedings. And so the state was gonna offer this as a consistent statement predating the proceedings.
All right. Sustain. Well, he can't, I mean, at this point, if that's the case, all I need to know is that he came and made the report. I don't know that, I mean, and it was consistent with what he was saying. I don't need to go too deep into it because what I'm trying not to do is retry the custody case, because that's not what's important to me.
Yes, ma'am.
Okay. All right. Anything else for this witness, Mr. Todd?
Just
Or-
one or 2 points of clarification. After the bond conditions were entered in this case, you text my client on February the 24th. This would have been a month after this incident happened, or maybe a little bit more than that. Did you not text her asking her that you wanted to be a family, you wanted to get together with her, and you wanted to be a family?
No. I do want that family, but not with the aggressive behavior that comes from her.
Okay, so Mr. Jimenez, it's too much.
Yes,
Let me ask you the question. Did you text her on February 24th of 2021?
not that I recall, no.
Okay.
Cool.
Okay. So you didn't text her about that. Then did you text her on that day or later that day, cussing her out? I'm not going to repeat all the vulgar language, but that you were telling her at that point that you hated her, that she pissed you off. Did you text her on that date later afterwards when she would not make contact with you? Did you not make these numerous profanities to her, text to her after the bond conditions were in place?
No.
Okay. And did you not say, I will also never stop wanting you, and in the later text on February the 24th after the bond conditions?
No.
Okay. Okay, I think that's all, Judge, that I've got.
All right. Does the state have anything else to present?
Just to close the statement, Your Honor.
All right. Okay, Mr. Todd, do you all have anything else to present on behalf of your client?
Yes, Your Honor. My first witness is Mrs. Rump. I would call her. She's out in the waiting room. I would call her as my witness.
Okay, hold on. Who's Miss Rump?
She is a friend of my client's who had direct contact with Mr. Jimenez regarding numerous occasions.
I don't know, Miss.
Okay, hold on, Mr. Jimenez, hush. So here's the question, Mr. Todd, because Miss Rump may have been what you needed for the custody case, but is Miss Rump going to be able to testify as to the contact between her client and Mr. Jimenez? I mean, your
Yes,
client
ma'am.
and Mr. Jimenez?
Yes, ma'am.
And it's not going to be hearsay.
Correct. It's going to be between her and Mr. Jimenez.
Hold on. Miss Rump and Mr. Jimenez.
That is correct.
And contact pertaining to him reaching out to Miss Dorsey.
That is correct.
All right. All right. So, yes, Mr. Brooks. Hold on, Mr. Todd.
Before she's allowed to testify, we believe she may be a defendant on an open case. And so I just want to put the court on notice that she's represented by attorney Christopher Walker. And so I don't.
Okay. All right. So I'll make sure she's aware when she comes in.
It's a reckless conduct charge appears to be. I can give you the case number.
Hold on a second on that.
It's in front of Your Honor as well.
Oh, wonderful.
She's on your calendar card.
What's wrong?
Mr. Todd.
Yes, Your Honor.
And so Ms. Rump, I believe, is a defendant in an open case before me.
Okay.
So, okay, Ms. Rump. So Ms. Rump, you're gonna testify under oath, ma'am. I'm gonna swear you in and you're gonna testify under oath. Understand that you have an open case pending before me that's being prosecuted by Mr. Brooks's office. So please be mindful that you don't want to delve into anything that might jeopardize your defense in that case. You understand that your attorney is not here to represent you.
Yes, ma'am.
And it's my understanding that Mr. Christopher Walker is your attorney.
Yes, ma'am.
You understand that Mr. Todd is not your attorney. He is the attorney for Ms. Dorsey.
Yes, ma'am.
All right, and you understand that you're entitled to have your attorney present if you make a statement under oath.
Yes, ma'am.
Okay, so Ms. Rump, are you willing to make a statement under oath without your attorney being present?
Yes, ma'am.
Okay. I'm kind of, all right, Mr. Todd, given that she has the constitutional right against self-incrimination in her case, please be mindful that when you're questioning her, we shouldn't get into anything that involves her case. I don't know if it's related or not. I don't need to know. All right,
Do that.
Ms. Rump, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, any objections from the state? Ms. Rump, you can put your hand down.
You're not, I guess I'm at a loss because Ms. Rump is co-defendants with Ms. Dorsey on the case that's coming
Okay.
before the court.
Mr. Todd, that's too close. She can't testify. I won't accept her testimony without her attorney present.
Okay. Give her her mother. You have a seat.
Okay, Mr. Todd, who's this?
This is the mother of Mariah Dorsey.
All right, what's her name?
Geraldine Dorsey.
All right, Miss Dorsey, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. So, Mr. Todd, your witness.
Okay.
Geraldine Dorsey,
Mariah.
my daughter.
So, Mr.
Yes, sir.
Todd, we can't hear you very clearly, so you
Okay,
need to.
Judge. I'm gonna move closer. Okay, Judge. Do you know Mr. Jimenez?
Yes, sir. I saw him several times.
Okay. Has he been over to your house?
Yes, sir.
Okay. And that happened, and there was a bond condition entered in back in January 2021.
Sir.
Okay. That date.
We're having trouble hearing. Could the opposing counsel restate the question?
Yeah, Mr. Todd, every time you lean away from the camera, we can't hear you.
Okay. Anyway, can you hear me now?
Yes.
Yeah, okay. Ms. Dorsey, at any time after January the 2021, did Mr. Jimenez come to your house?
Yes, sir.
Okay. And how many times did he come to your house?
I can't recall how many times, but I know he came over on Mother's Day and bring her flowers.
Okay. He came over to whose house on Mother's Day?
My house and with a plan.
Okay. And did you invite him over?
No, sir.
Okay. And was there other occasions that he came to your house?
Yes, sir.
Okay. So just explain to me when you come over.
We're losing you, Mr. Todd.
I'm sorry, George. I don't know what's. Was there other occasions where he came over to your house?
Yes, sir.
Was there other occasions where he boisterous, loud, and
Your Honor, I apologize to interrupt, but we still can't hear him.
Clear, Mr. White. Mr. Todd?
I don't know
Okay.
what's going on. I don't know what's going on with it, Judge. But
Okay.
anyway, I'm going to shift. When I speak, I'm going to shift over. That way I'll speak directly into the mic and then I'll submit it to the witness. Try
Okay.
to see, to hopefully combat that issue.
Okay.
Was there occasions that he came to your house that you had to ask him to leave?
Sir.
Okay. On what occasion? What did he do?
He slapped her down. She came upstairs and said he slapped her downstairs and I asked him to leave.
Okay, so Mr. Todd? Mr. Todd? So I'm gonna ask relevance because here's the thing. There's no contact provision on Mr. Jimenez. The no contact provision is on your client. So I get trying to establish that he's made contact with her to mitigate the fact that she's made contact with him in light of the no contact provision. But like, how deep do I need to go? Do we need to talk about every instance where he came over, where he slapped or didn't slap? I'm not sure that is helpful to me. Tell me why it's relevant.
It's just relevant because he is contending that somehow, some way, he was afraid, and also that he's testified unequivocally that he's had no contact either in person or by text message after the incident that happened in January. This witness is going to be able to.
Okay, you just muted yourself. Okay, so I get
So
where you're
Judge,
going with it.
yeah. So
So
there's been occasions where not only did he come to the house uninvited, Judge, but also there's been where he has committed physical contact with the defendant in this case, which I understand he doesn't have a no contact order, but obviously he's coming over there at will all the time. And I'm trying to establish the fact that, number one, he's not afraid. Number two, that he's numerous times come over there on numerous occasions. And we're talking about a period of from January, February, all the way up until August of this whole year.
okay, all right, Mr. Todd, go ahead.
Okay. Where we left off was there occasions where you had to ask him to leave your house?
Yes, sir.
Okay, what happened on those occasions?
Well, after he hit Mariah, I told him to leave, and I even called his mom and told his mom that the next time he came to my house and behaved in that manner, I was gonna call the police and get him arrested because he's not welcome at my house at all. Yes, sir.
Okay, Mr. Todd, I'm not hearing you. Okay, it works better with Miss Dorsey. So what I think you need to do is like pull back a little bit, pull the computer or the device back away from you, and then move over towards Miss Dorsey so that you all can be in the screen together. Okay, now push it back, push the computer back.
Okay.
There
Can you hear
go.
me?
Yes, both of you can speak directly into the microphone and be seen. And you don't have to
Fantastic.
bounce back and forth. Miss Dorsey, can you say something for me?
Yes, ma'am.
Okay, thank you. I'm gonna start my new job as a technical director. Go ahead.
Was there occasions where he came over uninvited?
Yes, sir.
Okay. And just tell us what he did when he would come over normally. Would he come over and do what?
He'll come over, he sleep over sometimes, and sometimes he'll come over and they having fussing. They fight in the sometimes.
And was this after the bond conditions of January 2021 that he came over to your house?
Yes, he came over one of the time that I can recall, he came over and he told me that they have AIDS, both of them. I called Mariah, I speak with Mariah. She said she don't know what he's talking about. I don't know.
Okay, but he did come over on a regular basis?
Yes, sir.
Okay, and did he sleep over and spend the night there?
Yes, sir.
Okay, and this has been after the bond conditions?
Yes, sir.
Okay, and on Mother's Day, what did you observe on Mother's Day?
On Mother's Day, I observed he pulled up and I asked him what he was doing there. He said he bring this plant for Mariah and Kingston, which is his son. And I told him just leave it outside. And she said she didn't want it. She told him she didn't want it. And he said, leave it outside. I tell him leave it outside, and it was outside.
Okay, and did he at any time here after the bond conditions were imposed, did he text you?
No, he haven't texted me. He called me
Okay,
from
so,
a WhatsApp number.
okay, so he's called you on the phone?
Yes, sir.
Okay, and how often would he call you on the phone?
He maybe called me once or twice.
Okay.
Maybe 2 to 3 times.
And what was he, what was he asking you? What was he inquiring about?
Mariah.
Okay, what did he tell
He said
specifically?
he loves Mariah and he wanted to be with her.
Okay, and this is after the bond conditions, correct?
Yes, sir.
Okay. Was there any other occasions
No, sir.
that he came to your house other than what you've already told us?
No, sir.
Okay, do you know whether or not he came to your house when you weren't there? You
No,
know?
I'm not, because I'm a travel nurse. So a lot of time I'm not at home.
Okay,
But for when I'm at home, that's what I can tell you.
okay. All right. That's all the questions I have, Judge.
Cross-examination, Mr. White.
Yes, Your Honor. The defendant is your daughter, correct?
Can you repeat, sir?
The defendant is your daughter, correct?
Yes, she is.
And you love your daughter, correct?
Yes, sir, I do.
Yeah, and you believe your daughter is a good person, correct?
I know she's a good person.
Yeah, and a good person is not capable of committing crimes, correct?
That's correct, but we are all made mistakes. We're humans.
Okay. And you said, Mr. Jimenez here came to your house uninvited. How do you know this?
Because I did not invite him to my house. And as far as I'm concerned, that is my home.
But your daughter invited him, correct?
When my daughter invited him to my home, she'll tell me, Mom, Aaron is coming over. She'll tell me. She'll ask my permission several times too. She'll tell me that he's coming over.
Your Honor, may I have a moment to confer, please?
You may.
Thank you. No further questions, Your Honor.
All right.
Were you home? Were you home at any time when Mr. Jimenez came over there to pick up Kingston, the
Yes.
child?
Yes, sir. Sometimes I'm the one who she tell me that he was gonna come, and I gave him Kingston. The mom reach out to Mariah, text Mariah and say she want Kingston. So I'll be the one that gave them Kingston a lot of time just to make both of them don't get in contact with each other.
Okay, that's all the questions I have, Judge.
All right. All right. Any recross, Mr. White?
No, Your Honor.
Okay. All right. So I'll excuse this witness. Mr. Todd, do you have any other witnesses to present?
Raise your right hand. You solemnly swear and affirm you about evidence you're about to give me the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
Okay, put your hand
All
down.
right.
State your name.
Hold on, Mr. Todd. Miss Dorsey, So you understand that part of this proceeding is part of the state's decision to prosecute you for the charges of battery, simple battery, family violence, battery, simple battery, family violence, and simple battery.
I'm just not learning that, ma'am.
Okay, so no, let's go back. You were arrested.
Yes, ma'am.
All right, and you were charged with offenses from the charges that you got when you were arrested,
Yes, ma'am.
and you had an arraignment
I
where you
believe-
came to court with your attorney before me.
Oh, yes, ma'am.
Okay, so this is not the first time you've heard about these charges.
No, I thought that this was actually.
Yes or no? And the reason I'm restricting your testimony is because I don't want you to say anything that might get you in further trouble. Okay,
Yes,
so you understand that this is part of the state attempting to prosecute you for the offenses that I've listed.
yes, ma'am.
And do you understand that anything that you say in this hearing can be used against you in the trial of this case or any further proceedings?
Yes, ma'am.
Okay, and don't tell me what you said, but have you discussed your desire to testify in this hearing with your attorney?
Yes,
And you understand that nobody can force you to testify and nobody can give you anything in exchange for your testimony.
yes, ma'am.
You have a right to remain silent and not incriminate yourself based on the Constitution of the United States.
Yes,
You
ma'am.
understand? Okay, so at this time, are you waiving your right to remain silent, meaning giving up your right to remain silent in order to testify in this case?
Yes, ma'am.
Okay, all right, so at this time, Mr. Todd, I find that your client is offering her testimony freely and voluntarily, so go ahead. She'll be subject to testimony and cross-examination.
Yes, Your Honor. Please state your name for the record.
Mariah Dorsey.
Ms. Dorsey, do you know Mr. Jimenez?
Yes, sir.
How do you know Mr. Jimenez?
He is my baby father.
Okay, do you have a child born between you and he?
Yes, sir.
What's that child's name?
Kingston Gione Dorsey.
Was that child born with a heart defect and heart problems?
Yes, sir.
Okay, and are you the sole caregiver for that child?
Yes, sir.
Prior to, well, there's been no order entered in this case. Prior to today, there's been no order where he's legitimized the child, correct? Correct?
Yes, sir.
Okay, and prior to this time, he had no legal rights to Kingston, correct?
Yes, sir.
Okay, and just so we're clear, even though he had no rights, did you allow him after the bond conditions, in this case, I'm talking about after January 2021, did you have any contact with Mr. Jimenez?
I didn't understand that question. Can
Did you have contact with him after the bond conditions were imposed? Did you have contact with him?
I did not make the contact.
Okay.
He came to my house asking for me to come back together with him.
Okay, so who did you go to his house or did he come to your house?
He came to my house.
Who initiated any contact with Mr. Jimenez?
Mr. Jimenez decided to come to my house out of nowhere. He just popped up.
Okay, and did you go over to his house? Did you make the initial contact at any time?
No, sir.
Okay. Tell us, what did he come over to your house for to do?
Came over to the house. He would ask for sex. He would ask for me to come back to him. He would sometimes at first he would just popping up to the house and just parking at the side and just staying there to let him texting me that he's in the area. I would ignore him and he would get upset. There was times where it got to where I had to ask my brothers and my mother to give him Kingston, and a lot of those times he would get upset that he did not physically get to see me. So he would return the child and told me he's not taking him. I also have that in text messages.
Okay. And did he initiate contact with you after the bond conditions?
Yes, sir.
Okay. Did he text you?
Yes, sir.
Okay. Do you have that on your phone?
Yes, sir.
All right. You can use that to refresh your memory. After the January 2021, tell us about his contact with you. Did he text you after that?
January 2021.
After that, you have,
Okay, after January 2021, he did make contact with me. He was trying to come over. He was sleep over. November of 2021 was actually my daughter's birthday month. He had that day, that week, same thing. I was telling him I didn't want to see him, didn't want to talk to him. He came over the house, and his intent was to sleep over and have sex. After him leaving, he didn't take Kingston. It was just, he just was there trying to see me, told me that he wants to get married and he wants us to move in together and things like that. And he's sorry that he ruined the relationship with me and his family because of he was absent in the beginning.
okay. So who initiated that? You contact?
Yes, sir.
Okay. Something happened on Mother's Day as an example. What happened on Mother's Day of this year after the bond conditions?
Mother's Day, I was actually out with my friend. I got a text message that I'm in the area. I want to see you. I just so happened to pass by the house just to see how is he's waiting for me, how is he trying to see me. Pass by the house, it's his mom's car. He's sitting outside of his mom's car. I drove straight past. We just wanted to go get some things from Walmart and chill at her house and watch TV and stuff. And I just talked about it. I was like, I don't feel comfortable. It's been like over 5 years, 7 years now. He hasn't really trying to do much. I'm just like, I didn't feel okay with going to the house with him being there. I knew of the flowers. I didn't take the flowers because with all the recordings that he was doing of me, where he was just constantly trying to find just anything just to use as blackmail if I left him or anything, including my son. I didn't take the flowers because I thought honestly there was possibly a mic or a camera in it. So I left it outside.
After these bond conditions were put in place, did you initiate, in other words, did you make the move to contact him?
No, sir.
Okay. Any contacts that were made, did he initiate, start them?
Yes, sir.
Okay. As far as texting was concerned, did he text you after the bond conditions were in place?
He texted me. I blocked every single account that he made. He made a fake one. He had also his other girlfriend that he knew way before me decided to contact me, which is Liara. She decided to contact me asking if she could also see my son. They want him. They wanted to form a relationship with me too. And I did not respond. And she just been making random more accounts. And I had distress to her that I wanted her to leave me alone. If she's with him, please enjoy him. So can Jasmine. I'm just here for my son. I'm trying to finish school. My cousin recently died. I'm trying to be there for my family in this hard time. And I just didn't want anything to do with it. I just blocked every single account.
He persist, even though you blocked his account, did he persist in trying to contact you after that?
Yes, sir. He contacted my friends and then was trying to find out what my whereabouts were.
Did you at any time initiate this contact? Did you make the first move?
No, sir.
Okay. I think you mentioned it, but did he come over to your house and actually spend the night over there?
Yes, sir.
Did you initiate that or did he initiate that?
He initiated it because of this case going on my hands is in a lion's mouth. I don't want to do anything to tick him off anymore because the ball is in his court. He could do whatever he wants with me at that point. So therefore, I just feel like I'm hopeless.
Okay. Did you at any time threaten him?
No, sir.
Text messages or whatever saying that, did he accuse you of threatening him?
Because anywhere in his, I don't understand that. Can you be
okay? Did he at any time tell you that he felt threatened by you?
Never told me he was threatened. He was just trying to stay over my house, ask me why I was acting different. He didn't like the fact that I wasn't comfortable with him all the time. Like I wasn't like being more relaxed and acting bubbly how I normally would. So he was upset about it. So he just was, one thing led to the next. He told me he was gonna kill himself, all other things. He's mad about the fact that he can't bring me to his house. His family now doesn't like me because of what he did and stuff like that. But you know, that's behind us. It's time to heal.
Intentionally violate the bond conditions? In other words, did you contact him to violate the bond conditions?
No, sir. After I came out of jail, I was ready to at least go back working and trying to make some money for my kid, because I took the months before that I was in the hospital with my son, couldn't work because I'm trying to find out if my son was going to make it out alive or what's going to happen next. So I wasn't even able to work from that point. I went to go work straight after that to make some money up. My people had to get me out of jail. I had to help pay the bills and stuff like that. So my number one goal was taking care of my kids and maintaining my home.
Is that what you did?
Yes, sir.
And some testimony here, did you at any point damage his vehicle?
No, sir. I never damaged his vehicles for even when I was pregnant with his child, and he ghosted us, wouldn't talk to us or anything, and never would damage anything of his stuff from even years before, from 2015. No matter what the circumstances were, I knew, take everything with a grain of salt and just move on. Just focus on yourself, make everything happy for you. I continue to occupy myself with going to school, educate myself so that I could be a better person.
Okay, and were you aware of, was his car, to your knowledge, ever had gunshots before?
There was a time he was supposed to pick up Kingston, and he showed me that he was at a Red Roof Inn when we was like videoing, and he was like telling me
Objection, Your Honor, lack of personal knowledge, hearsay.
no.
Mr. Todd, I can't hear you so well, so
Well,
can you?
I'm sorry. I said that's, she's testifying as to what Mr. Jimenez told her.
We was on FaceTime.
Yes, ma'am.
Your Honor, if I may respond, Mr. Jimenez is not a part of the state. The state is the party.
He's a witness that's testified, Judge, and he's testified. He's already testified, so she can testify to personal contact and what he's told her. I mean,
Okay, hold on. Mr. Todd, I see where you're going. I'm gonna give you a little leeway. I'm gonna overrule the objection, but I just really like make the point, move on.
okay. Did he tell you that his car had been damaged before?
Yes, sir. He had a lot of enemies out on the street. I know one time he showed me that he was out at Red Roof Inn. He told me he will be out soon. I didn't know what it was, but I felt like he went there to go meet a girl. I guess it was possibly
Miss Dorsey, focus.
okay.
Was the car damaged or not? Tell me
The
about
car
the
he showed
I
me
wanna
was
hear anything
damaged.
else about another woman.
Okay, he showed me it was damaged. I didn't know if it was gunshot for sure, but I saw the windows were broken, his wallets were missing. He said that he lost money. So I know that morning he called me, from the night to the morning, he's still at that hotel. So that's what got me to thinking maybe it was something personal.
Other people, and when I say that is other people, his girlfriend tried to contact you?
Yes, sir.
Okay. Told him, no, you don't want to have any contact with them?
I just blocked them. And
Okay.
one of them, for instance, I did tell them, please leave me alone.
That's all the questions I had, Judge.
Next, sorry, Your Honor.
All right, Mr. Todd.
Yeah, sure. That's all the questions I have at this point.
All right, Mr. White, cross-examination.
Yes, Your Honor. Ms. Dorsey, earlier on direct examination, you said you never initiated contact with Mr. Jimenez. Isn't that correct?
Yes, sir.
Okay. And you were here when I talked to Mr. Jimenez during his direct examination, weren't you?
Yes, sir.
Okay. Your Honor, permission to publish Exhibit 1.
It's admitted, so publish it.
Oh,
All right.
I couldn't hear what he said. I couldn't hear what he said.
He asked for permission to publish Exhibit 1. It's in the,
Oh.
it's admitted, so he can publish it.
Oh,
States Exhibit 1, Your Honor.
I got you, sir.
Yeah. Mr. Jimenez, referring to States Exhibit 1, on June 27th of 2020, you messaged Mr. Jimenez, "Daddy, come get our love child," didn't you?
Judge,
No, sir.
Judge, he's talking about 2020. That's before the incident even happened.
Yeah, I did. Okay. Your Honor, on June 27th of 2022, as published into evidence, the defendant messaged Mr. Jimenez, "Daddy, come get our love child." The defendant messaged Mr. Jimenez, "She stays in a one-story house." The defendant messaged Mr. Jimenez, "You've got 3 days." After responding to Mr. Jimenez's request to
Objection, Your Honor. Is he asking a question? Is he?
Yeah,
going to-
Mr.
he's making
White.
a statement. He's making a
Okay,
statement.
so
here.
Mr. White, generally when you ask to publish something, you show it to us.
Okay. Here is the beginning of the conversation, Your Honor.
Your Honor, because of the difficulties of digital testimony, the state elected to publish by reading it into the record. And Mr. White was going to read it verbatim as it's written on, as it came through the text message. So in green would be one person and then the response and then back and forward. He obviously can hold it in front of the camera, but the text is so small that the court won't be able to make it out, I'm sure.
Okay, and y'all can't scan and share?
Because we haven't seen it, Judge, obviously.
All right, Mr. Todd, I'm trying to,
I figured since it was already in evidence, I thought it was already scanned.
if it's scanned already, then he can share it.
And Your Honor, forgive me, I was not in the room when
I bet you, Mr.
the tender, but
We're
He tended
scanning right now.
it on the paper, but that I believe was because it hadn't been admitted yet. But if you want to publish it, we can have it scanned and share it. That would help. Because Mr. Todd and I haven't had an opportunity to read it.
Mr. Todd, what is your email address?
Joseph@josephmtodd.com.
Are we talking?
Well, no.
Is he talking?
Mr. White, you're muted.
Your Honor, we are published the evidence on the screen of Exhibit 1. I'm I can't.
Okay. Scroll down to the bottom.
Could be Liara. It could be the other girl. Cause he with this other girl too. So and she
All
got
right,
2 kids.
Miss Dorsey, hush.
Oh, I thought on the mute.
Off of mute.
All right, Mr. White, I've seen it. I've read it. Okay.
Ms. Dorsey, on June 27th, you messaged Mr. Jimenez, "Daddy, come get our love child," didn't you?
No, sir.
So you didn't text him any of the messages published in Exhibit 1?
No, sir.
Your Honor, may I have a moment to confer?
Okay, Mr. White, but confer about everything you need to confer about and anticipate some things because it's almost 8 o'clock.
I apologize, Your Honor. This is the last time. Ms. Dorsey, earlier on direct examination, you said that you never wanted Mr. Jimenez to come to your house, right?
Yes, sir.
That you didn't want him to spend the night.
Yes, sir.
So you never wanted any sexual relations with Mr. Jimenez.
Yes, sir.
So you didn't send a message telling him to come over in Exhibit 1.
And I said a what, sir?
You didn't send a message that you wanted him to nut in your pussy in Exhibit 1.
No, sir.
No further questions, Your Honor.
Can you hear me, Anna?
I hear you.
Okay. Dorsey, on this text message that they showed, there's a telephone number on there. Is that your number?
No, sir.
Did you send this text message here that they've shown to you? Did you send that to him?
No, sir.
Has he, that is Mr. Jimenez, sent you messages with fake phone numbers and fake information on it?
Yes, sir.
That's all the question.
All right. Any
That's
response?
that's all the evidence that we have, Your Honor.
Alrighty. All right, so Mr. Todd, your side is rested. State doesn't have any more witnesses, only argument. All right, I'll hear from you all now.
Thank you, Your Honor. You want me to go first?
You may.
Okay. If it please the court, Your Honor, this is the state's motion in this particular case to, I guess, either modify the bond or do something with the bond in this case. Obviously, it's a serious situation because of the fact that they want to somehow take the liberty of my client away. I would submit to the court, based upon the totality of evidence that has been presented in this case, that this gentleman has contrived the situation that started back in January, Judge, in this case, and it's gone now for however long it's gone. He never legitimized the child, never had any legal rights to the child in this case, did not pay child support, nor did he have any legal rights. My client, the parties got together. They were trying to work it out between themselves. Unfortunately, they had spats back and forth, but there's no evidence that my client, as she just testified to, unrefuted, that whatever they've just presented to the court was not her telephone number, was not her text number, that she did not text it to him. There's no evidence to the contrary. It's uncontroverted. He has no way of knowing. It came from a number, an unknown number. He did not testify it was from her number. So therefore, Judge, you have the situation here. I believe at the very least you have is a conflict in the evidence. The state has the burden of proof in this case. Judge, they haven't even carried the burden. But even if you want to go to the lowest, Judge, there's definitely a big conflict in the evidence in this case. Bear in mind what we have here, Judge, is the fact that this gentleman, who had no legal rights to the child, had not legitimized the child. Now, after this, he files a legitimation case, Judge. And so therefore, a lot of this stuff is contrived from the fact of he has done or tried to do whatever he could to obviously make my client look bad, but more importantly, to somehow get her bond revoked in this particular case, or modified, or whatever the case may be, when it's clear that he was the person that made the initial contact. Yes, my client was not supposed to have any contact, but you have a situation here that he continually wanted to get back with her, wanted to have a family, wanted to be part of the family, that he's the one that was the aggressor and made the contact and gone over to her house, went to her house. Testimony has been that he's been the one that's been the aggressor, and he's the one that has continued to make the advances towards my client. So even though, yes, she was not supposed to have any contact with him, but he continued and continued to force himself on her to the standpoint of going over there to get the child, to visit with the child. And my client even allowed the child to go, even though she had no legal reason or legal obligation, allowed the child, as testified from them, to stay over there with the parent, with him and his parents, or his parent, is for the visitation and so forth. So anyway, Judge, it was all as a result of this lawsuit. We had the civil case. And the reason I bring that up is because this was all to build up a case to try to get the civil case for him to try to get custody. That's what he was trying to do, even in this situation, going back before this, trying to get custody. That's what he was trying to do. It didn't work. It failed. We say based upon the evidence, Judge, you've heard it. You're smart enough, Judge. I don't need to say anymore. Obviously, there's not enough evidence here to revoke my client's bond and take her liberty away based on what Your Honor has heard in this case. Thank you, Your Honor.
Mr. White?
Yes, Your Honor. Your Honor, this case is a bond revocation case. It's not about legitimizing a child. It is not about who won custody. It is a bond revocation case. And the terms of her bond was to have no contact with Mr. Jimenez. And the proof has shown that she violated that no contact multiple times. Now, the defense has tried to bring forth, she didn't initiate the contact. She didn't initiate the contact, but you heard from Mr. Jimenez what happened. He didn't initiate, he only responded. You saw the text message exchange between the two parties of her initiating contact with her, of him asking her, if you want contact, let's meet at the police department. She wouldn't have it. She continued to threaten him with countdowns. You have 3 days, you have 2 days. She made threatening contacts to him, provoking contacts to him. Furthermore, Your Honor, the state has brought forth a witness in her mom to testify that Mr. Jimenez initiated all contact, but her mother said that she did not allow Mr. Jimenez in. The mother herself, she never said her daughter didn't allow him. Everything she knows about the situation, she was told about from her daughter, who she loved, who she said was a good person, who she said would never commit a crime. But we know that's simply not true. We know that she's committed multiple. And then finally, going on to this child revocation situation, the defense keeps on bringing it up, that it happened 2 days ago. Mr. Jimenez filed a police report in June, long before 2 days ago. He came to the solicitor's office for an affidavit in July, long before 2 days ago. So when we look at the fact that this is actually a bond revocation hearing, and that she violated the terms of her bond by contacting him, initiating contact with him, that enough should be suffice to revoke her bond. But furthermore, Your Honor, when looking at the Ayala factors, this defendant poses a significant risk of intimidating the witness because she has already reached out to the victim, the witness, and threatened him. And furthermore, she's also a risk to reoffend as she has already violated her bond order of no contact with the victim multiple times. And because of this, Your Honor, the state asks you to revoke the defendant's bond.
Okay. All right. So one of the most serious things that I get asked to do is to revoke someone's bond, because pre-trial detention is for the purpose of establishing that this person is going to appear for court, and then the public policy and the Constitution, the statutes, they all lean to pre-trial detention not being prolonged beyond the point where we are assured that the person is going to show up for their hearing or whatever court proceedings are there, and they're also not going to pose a danger to the community. And so when someone brings evidence to me that states that someone has violated a court order that is imposed to keep the peace between parties, then I take that very seriously. The issue that I have is that Exhibit 1 was admitted, but technology being what it is, Miss Dorsey has denied that that is her, and Mr. Jimenez's testimony is not enough to sufficient to establish that the phone number on that on those text messages actually did come from Miss Dorsey. The other issue is that these parties have had enough contact since January 7th of 2021 that the court is not, I mean, prior even to the June 27th through 29th situation, there was contact back and forth. They freely exchanged the child. They went back and forth with each other. Both sides have credibility issues in light of the court. And so The problem that I have is not that I think Miss Dorsey is a danger to Mr. Jimenez, but I think they might be a danger to each other and the child. I seriously have an issue at this point where I wish I was still on magistrate court, where I could impose restraining orders that keep both of them from having contact with each other, because I think Mr. Jimenez is just as dangerous in this situation as Miss Dorsey. I think that they are both somewhat obsessed with each other. I think that this situation has gone on for quite some time. I think that both of them are individuals who need to mature substantially and don't understand that a co-parenting relationship does not involve threats, does not involve over-sexualized language, does not involve showing up at somebody's house, does not involve getting involved with the other person's other parties. It is just ridiculous. Just the amount of information I've heard, which I know doesn't come close to what was argued in the custody case, but you both are not showing that y'all are ready to be parents. This is horrific. Mr. Jimenez, if you wanted to have contact, you know that there are charges pending in which you are the complaining witness against Miss Dorsey, but you continue to have contact knowing that there was a no contact provision. And even though the court has not established jurisdiction over you in this case, you're the one stating that she victimized you. Instead of going to the court and establishing a way through the courts to see your son or to legitimize your son, you just kept going to see them without any regard to the fact that there was a no contact provision in this case. Ms. Dorsey, you also know that there's a no contact provision in this case. And as I often tell people when they come before me for arraignment, and I'm pretty sure I told you this, if you are contacted by the other person, then you are to keep a record of it, but you are not to respond. Keep a record of it, but don't respond, because you're the person who, if it results in contact being made, you're the person who faces having your liberty taken away and you being put back in jail. And you can also be charged with a misdemeanor or a felony punishable by more than by 10 years in prison, a $10,000 fine, or both. I know the speech. I can say it off the top of my head. If you woke me up in the middle of the night, I could say it. So I know I told you. But you two are acting like there's
some kind of technical situation.
Okay.
all right. So in the middle of what was probably a perfect rant, the kid cutoff time got me. I was on the wrong network. So here we go. At this point, I am really just, I just don't know what to say. I've heard evidence and testimony. Is the state there? Because I see a black screen. I need to see the state.
Your
All right,
Honor,
so-
we're under Charles Brooks.
I've heard.
I was just trying to say that we were here.
Yeah, we're back. So I've heard evidence and testimony from both sides. I am disappointed deeply in both sides. I wish I could impose a no contact provision for both sides, Mr. Jimenez not to have any contact, but this is what I want to let you all know. One, I don't find this, is the state frozen? Somebody wave.
No, Your Honor. Can
Okay,
you see this?
so one, I don't find that there's sufficient evidence to revoke Ms. Dorsey's bond, because there's been no evidence that assures me, in light of technology, spoofing, and the animosity between these two parties, that those messages were actually sent from her. Number one. Number two, there's been more than enough evidence that Mr. Jimenez, even on his own testimony, has spoken about contact he's made with her, using the child as an excuse to make the contact, but making the contact nevertheless. So Mr. Jimenez has not evidenced to me that he was afraid for his life or safety in light of charges that are existing against Ms. Dorsey. I just can't tell you how y'all just really don't understand how crazy y'all look. Really don't understand that I'm afraid that there's a child that has to grow up in this atmosphere. Really don't understand that neither of you are going to make mother or father of the year. How you really don't understand that it is bigger than both of you, and y'all are playing out these little petty issues that y'all have with each other. And the criminal justice system is going to do what it does, but y'all haven't come to the realization that y'all have to grow up. You have to respect each other as the parents of the same child. And if the court imposes an order that there's to be no contact, then y'all are to listen to that order. Now, this is what's going to happen. I'm not revoking the bond at this time, but Ms. Dorsey, please understand, should there be competent evidence sufficient to convince me that you are in fact having contact with Ms. Jimenez, then I will put you in jail until such time as this case is concluded. And so understand, my understanding from the testimonies that you have more than one child, and I'm sure your mama as a traveling nurse doesn't want to babysit your children. So be mindful of that. Mr. Jimenez, please understand that the court will not take it lightly if you have contact with Ms. Dorsey of any kind. Anything that is not through an attorney or the courts is going to be frowned upon strongly by the court. Are we clear? Y'all seem to be frozen. So if anybody's hearing me, let me know.
Yes.
Because I don't understand how y'all don't understand how this makes you look. Ms. Dorsey, you got a lot to lose. You got stuff on the line. You got 4 counts against you, and with murder being considered, ma'am, you looking at some serious charges and some serious time if you were convicted. Keep that in mind. Mr. Jimenez, you can always be charged with something if your contact gets out of line. Your conduct gets out of line. I cannot believe what I've heard here today from 2 people who call themselves parents. Young, but at the point that you have the children, you got to grow up, both of you. And Mr. Jimenez, really, your conduct is scaring me a little bit. Because if any of this is true about you just showing up at her house, lurking around her doorstep, dropping off flowers to your baby mama when she didn't ask for them, that's scary to me. That's stalkerish. So at this time, this hearing is concluded. I am not going to issue a bond revocation. Mr. Todd, based on the principles of fundamental fairness, you can present a proposed order that denies the state's motion for a bond revocation in this case. You can be as simple as that. Everything else I've said is on the record. And at this time, this hearing is adjourned.
Thank you, Your Honor.
Yes, Your Honor.
Order to the court with a copy to the district.
Yeah, you can just go ahead.
Yeah. I will
See,
do that.
just copy the other side and send it to through Ms. Val until my new staff attorney is online.
Okay, thank you, Your Honor. Good evening. Sorry to keep you so late.
Right. Thank y'all.